Welcome back to Legal Alternative Podcast with me, SamPawson. Nils, welcome back. I missed you last week.
A week
You
away.
a week away, so we did have Madeline in your absence. Really interesting chat on the menopause, but no, great to be back. How have you been?
Good. Try not to melt.
Yeah,
Try not to melt, yeah.
yeah.
I had a meeting yesterday and it was just absolutely roasting.
Yeah, it's very apt with we're not
Mm.
with what I'm talking about today in terms of melting. So Nils, what we got coming up today?
So, usual legal update. I'm going to be talking about some important changes to data protection. That really interesting subject, data
Yeah.
protection, but this is really important that we flag this up for people. Usual chat about what we've been doing outside the office, and then you've got a really good question.
Yeah.
Excellent.
Yeah, in terms of in the inbox, I think I'm kicking us off. As I say, with us both melting, it's cooled down a bit of time of recording for listeners. It's the Tuesday after the very hot Monday,
Yeah.
so actually very apt questions in my inbox, and I've had this both ends of the heat spectrum. So what I'm dealing with now is issues about ultimately what are companies' obligations during a heat wave or to deal with office temperature. I think as we've all worked in office where we've had aircon battles, questions about what is the optimum temperature. What I'm talking about today is more of the extremes. So it's, days like in the summer at the moment where the office can be extremely hot if you've got no aircon, or equally individuals who may work in, outside or in atriums where it can be very cold. So ultimately question of what is your duties as an employer. So it pinges a bit on both of our areas. So, jumping obviously on the health and safety and regulatory front, but from an employment perspective, obviously, general obligation is to the duty of care that you have to your employees to make them safe ultimately, and that's where you will come in terms of risk assessments, which I'm assuming you suggest will be carried out in terms of heat as one of the factors. The key issues in terms of what I wanted to talk about is there's actually no legal minimum or maximum temperature. So if you have employees who work in an office, you don't have to have it above a certain temperature or indeed below a certain temperature. I think there's some suggested guidance that if you're inside, it should be really more than 16 and probably no higher than mid-20s. But ultimately, no legal requirement. So if employees come to you and say the office has to be 20 degrees Celsius, not actually legal basis to doing so. So, when it's a heat wave, general good practice, open windows, shade, drinks, water, etc. The key things I wanted to talk about in terms of the risks and what I'm dealing with in practice is the extremes and actually where you have risk of claims. And there's two main things I wanted to talk about. The first being, as you probably imagine, potential claims of discrimination, and where we're talking about disabilities. So where someone, for example, may have a disability that is then obviously makes them more vulnerable to temperature changes, so medical conditions that, again, someone would suffer more in higher temperatures or lower temperatures. It's then a question of, do you as an employer have a duty to make adjustments and reasonable adjustments to that workplace? So that's where we're not just saying, actually, it's a case of grin and bear it. It's actually, do we have to make any substantial changes to the office to make that adjustment, and is that reasonable? So that may be either, obviously, an extreme example of installing air conditioning, fans, other kind of lower cost things, but that duty is there. It's obviously going to be very fact sensitive. We're going to have to look at that disability. And then the key in these cases is that, as I said, and often for the vast majority of employees, installing air conditioning isn't going to be a reasonable adjustment for most organizations. At the bigger end, maybe that would be the case, but for the vast majority, it wouldn't be. But it's about looking out for those cases. Is there anything you can do? Can they work from home, for example, that day if that environment is a bit cooler, or anything else they can do? Can we change their hours so they're not working through the middle of the day? Simple things like that. We live in a country where heat waves aren't that common.
Yeah.
So the cases actually I've done with are the opposite, really, where it's employees who are exposed to frequent cold temperatures, often those facilities, people on receptions where it's an atrium or partially outside or a door is open all the time. You're having those kind of cases that we have to be aware of. And something I would flag to companies if you are at the moment getting emails, moans and groans, it's too hot in here, you have to make this cooler. Just because you don't have a legal obligation to do that, what we talked about our fair case that you remember I did is we need to be careful that those moans and groans, do they become grievances and do they amount to a protected disclosure? Because then if we were to dismiss someone who made those moans and groans, we're getting into the realms of potential automatic unfair dismissal. That threshold is very high in terms of claiming an automatic unfair dismissal, but we don't, someone, if they're making a protected disclosure on health and safety grounds, for example, we don't need they don't have to prove ultimately that there was a health and safety infringement just because they believe their health and safety and their health is in danger. Can it amount to a protected disclosure? Is it then in the public interest? Often they can say yes because of the temperature. So we need to be careful. So yes, we should manage moans and groans with common sense, but let's just kind of ultra cautious if this is, repeat. Someone saying, I am too hot every day, I'm too cold every day. And we manage that process. And then if we are making judgments about that individual or dismissing or any other detriment as a result of those complaints, we need to be careful.
Yeah.
Any views from you, Nils? I'd say covers a bit of your work in terms of health on the health and safety side.
I think ultimately it's the employment and that potential path anyway.
Yeah.
To where it becomes and it snowball. That's a bad pun.
Yeah.
And then we're talking about hot weather, but when that snowball situation arises, I think that's more likely to happen than a PI claim, for example, because of the weather, or even a regulator coming in. You might get something like an improvement notice saying it's too hot in here, these are the measures that you need to take, or it's too cold in here, these are the measures you need to take. But I think actually that scenario you've described there, the employment one, the employment law problem is more likely to occur than either getting injured because of the heat or getting regulatory involvement. So it's interesting because you probably would think it's more likely that it would be my side of things.
Yeah,
that
it would, but it's
problem.
I think so. But that, and again, as employers, we understand the frustration of people. There's not a lot you can do. There's not, you can't change your facilities overnight. You kind of and people love to moan and groan about it. It's I'm sure yesterday we both did the same. You speak to a client first and they say, "Oh, it's hot." It's just kind of human nature. But just be careful when those moans and groans can amount to something else. Data protection then.
Yes, so I'm going to keep an eye on this. So we need to update the listeners and watchers on the new data protection bill. I'm going to speak about next week whether this has come into effect. But what it's looking like, those changes will be not a radical departure, but enough of an evolution that we can't just sit as lawyers or as business owners that are our clients in the main and do nothing. There are some changes that require perhaps tweaking of the policies that hopefully our clients have in place. So changes that are, as I say, not radical, but in particular around marketing and direct marketing. So if you're in that game, you've got to be aware that there's changes in that area and you do need to update your data protection policies. So just quickly running through some of the changes that are proposed. There's going to be the definition of scientific research has changed and rules around consent on that. I don't think that'll affect many of our clients. What will affect every client that we have is that there's now been changes to lawful bases for processing data, and actually examples have been given of what a legitimate interest is in that area. So you may remember we discussed in the past, one of the bases on which you can justify processing data is that it's in your legitimate interests. The first time we've got some examples around that. So those include processing that is necessary for the purposes of direct marketing. So rather than relying on consent, which I've seen clients try to do in the past, and I actually think that's a bit of a fool's errand. To rely on consent when you direct marketing is going to be very difficult. I would have to say to you, do you mind that I send you this email? And then you come back and say, of course not. You can rely on legitimate interest, and that's now an example that's been given. There's a couple of others that are less applicable, more niche, but there are some further examples of what legitimate interests amount to. One of them being intergroup transmission of a client, employee, or other individual's personal data for internal administrative purposes. So it might be Chadwick Lawrence HR team passing data to SamPawson's employment. So they're important. There's been some clarification around purpose of the limitation principle, which I don't particularly want to go into a massive amount of detail because that is quite niche. A relaxation on the rules regarding automated decision making, particularly for high tech industry, that will be relevant, and introduction of a more risk-based approach to data transfers. These changes also apply to what's known as PECA. So they have increased the fine provisions for if you breach what's called PECA.
Okay.
So the ICO's enforcement powers in relation to PECA and Data Protection Bill are now the same. That's a maximum fine of the greater of 17.5 million or 4% of the previous year's worldwide annual turnover. In terms of the implications for business, what all these technical changes mean is that higher fines are obviously available, so there's greater risk for businesses, particularly if you breach PECA. And that the ICO has in the past actually taken more enforcement action in relation to breaches of PECA rather than data protection breaches.
Yeah.
But also it's going to be vital that you update your data protection policies. And in particular, bear in mind that website cookies are managed through the PECA regulations rather than GDPR. So it's important that you bear in mind the ICO actually uses an automated scanning system to detect non-compliant cookies. So that is a risk area for businesses now. And with those fines increasing in relation to that, that's really the risk area I would suggest. So it's important, two things. One, being involved in cookies if you are looking at that. Yeah. Two, update your data protection policies. Yeah. Those are the changes from that. Just to let you know what PECA is, it's the Privacy and Electronic Communications Regulation.
I obviously knew that off the tongue. It seems to me a bit of giving in some ways in terms of legitimate interest seems helpful. As you say, and I'm guessing the advice is then, because there's been a definition of legitimate interest in some examples, it did make your policies adhere to that and weave that in. The little bits I see, Nils, is consent, as you say, is always still used. Sign this, but actually the detail is what's helpful in these cases.
Yeah, so if you're in direct marketing, if you're in research, if you're in automated decision making, those are the areas where the changes really bite, and you've got to make sure that you update your policies.
Fabulous. In terms of questions, and then I'll do a question, and we'll see what you've been getting up to. You've been doing more interesting stuff than I have. I'll be quick on the question because it's one we have dealt with before, which is again coming out, but it's something we're getting all the time. So I wanted to deal with it. Which the question is: can an employer change its disabled toilet into a unisex toilet, which is accessible to all employees? So again, this has come off the Woman for Scotland case, dealing with obviously the definition of sex and a woman under the Equality Act, obviously dealing with transgender facilities. So still getting a lot of this, and we had a more detailed dive into this in previous episode, but I just wanted to kind of again clarify this on facilities because people are getting very, probably understandably confused on facilities. And this suggestion of using the disabled toilet as a kind of, for want of a better term, of a facilities for all is being suggested by a lot of companies. And I can understand why, but sadly it's still without risk. And I think I talked about last time, Nils, that we've got this issue now where we have protected characteristics competing against each other. So your duties under the Equality Act for any protected characteristics in terms of facilities is where you can provide facilities for that protected characteristic. So there is a duty still under the Equality Act for any transgender employees where practicable, and that you need to provide facilities. So just in a way similar when we were talking about heat and the provision of facilities, we are balancing risk here, and that risk in terms of proportionality is obviously going to be measured on in terms of the size and resource of that organisation. I actually think, although it may be an honourable, the reason behind it may be honourable, that actually if you have existing facilities for disabled employees, relabeling them, I actually think causes more of a risk than a defence ultimately not to provide. Because again, arguably you need to provide now male facilities, female facilities, disabled facilities, and potentially facilities for transgender employees. For a lot of organisations, having 4 separate toilet facilities is going to be difficult. So I actually think relying on a proportion proportionality argument of we can't have the size and resources to provide those facilities is probably a safer bet than what you risk with removing a disabled only access. Is then you've got a risk obviously of discriminating against disabled employees who need those toilets generally for accessibility. So if you're taking away in a way that accessibility only facility, I think that is more of a risk of a claim than actually saying we would love to provide facilities for all, we just do not have the size and resource of an organisation to do so. This is obviously then a different answer if we are dealing with large multinational companies who do have the resource to do that, and then the answer is you should be providing facilities for all. So look at your pre-existing facilities. If you are a wash, excuse the pun, with toilet facilities, then yes, think carefully about how they are designated. Otherwise, use your judgment. Don't rush to judgments and look at those facilities. Don't know anything to add.
I was just wondering if you don't have the ability to provide the 4 sets, if you like. Presumably, the best thing to do would be to offer the choice. Have to say to an individual, you choose whether you use the male or female.
And that in extreme examples, there is no perfect solution because some of your, if we're dealing with places that don't even have disabled facilities, you may have a case where you've got a transgender employee who's saying, I need facilities and I'm not prepared to use the facilities either assigned by birth or otherwise. And you've got female employees that are saying, well, I equally want facilities that are protected by my sex. It's just incredibly difficult. And there is no absolute right answer. It's, I think, as you say, all we can do is case by case, do it by case by case. And I think if last resort, just ask. We're going to have to use judgment and try and reach a solution that either offends fewest people or limits your risk as much as you can.
I mean, I've worked in offices where there's just one facility for all.
Exactly.
So it's doable, isn't it, in terms of a solution being found?
Yeah. Absolutely. I jumped the gun on the question. We're normally out of the office. Tell me about you being at the races. I unfortunately was unavailable, but you were the York races.
Fantastic day. I had one winner, which meant I just about broke even.
You did better than most from what I hear with your one winner. So I don't know what that says about the horse racing knowledge of the Chadwick Lawrence employees.
But I did my usual thing of picking a horse based on the colours that the jockey wore, which is obviously foolproof. But as a follically challenged man, I made the huge mistake of not putting sun cream on.
No hat, no sun cream.
Up the next day in agony.
Right,
really good doing. Thank you to Bethan for sorting all that out.
Yeah, I saw some impressive burns from half of my team, so I don't think you're alone on that. And we've both got, again, rugby coming up for all of our clubs. We're doing okay, I think, is an overall. And we've got the football fixtures have come out, so we're both plotting football for next year at all our clubs as well.
Yeah, so Barnsley and Huddersfield Town.
Yeah, early has end.
Which is good, but Leeds doing very well. Bradford continuing to do very well. Halifax still doing pretty well as well. So I think this might be our best year.
Yeah, Wakefield, I think, again, first good season. So all very positive on the Chadwick Lawrence sport front.
So good stuff. Yeah, been a pleasure.
It has. Lovely to have you back. It was, as Nils says, data protection will update next week. I've got loads more in the office. We hope we will cool down, but thank you for listening.
And from me, thank you.